A court just sent a warning to permit offices across America. If the government buries your carry application in paperwork and delay, that delay itself can become the constitutional problem. And here's why that should grab your attention right now. What looks like a boring permit backlog can turn into a backdoor denial of your rights. And the people pushing back now include federal judges, the U.S. Department of Justice, and a big group of states. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from making a huge mistake with your carry permit, your travel plans, and your freedom. Hit that button now because these legal changes move fast, and most gun owners hear about them way too late. Here's what just happened, and I need you to catch this first part clearly. This is not some magic nationwide order that erased every permit law overnight. A lot of people hear a headline and think, that's it, permits are dead. No, that is not what happened. What did happen is something more realistic, and in some ways more important. Courts are starting to take a harder look at permit offices that drag their feet so long that the delay starts to look like the denial. First thing, look at Los Angeles County. A federal judge allowed a major lawsuit over concealed carry permit delays to keep going. That matters. Why? Because the sheriff's office tried to get the case tossed out. The court said no, at least on the claims focused on long delays. That means the basic argument survived. If officials take way too long to act on a permit, gun owners can challenge that in court. Now, this is where it gets interesting. The complaint was not about a tiny delay of a week or two. We're talking about alleged waits that stretch for months, and in some cases, much longer. According to the legal fight, some applicants said they were waiting up to 2 years. Imagine that for a second. Imagine you do everything they ask. You fill out forms, you pay fees, you show up, you stay clean, you follow the rules, and then the office just sits on your file while your right stays frozen. But here's the crazy part. In a separate development, the Los Angeles County Sheriff's Department later agreed in principle to a settlement schedule tied to California's 120-day legal deadline for processing a completed carry application. That does not mean the whole battle is over. It does mean the pressure got real enough that a compliant schedule became part of the conversation. And then came the move that shocked a lot of people. The DOJ stepped in. Yes, the Federal Department of Justice filed a lawsuit against the Los Angeles County Sheriff's Department over permit delays. That was a huge signal. The DOJ said it reviewed more than 8,000 carry applications and found evidence of extreme delay. The department said only 2 approvals had been issued out of those applications, and that some interviews were being scheduled as far as 2 years out. Let me break that down for you in plain English. The argument is simple. If the state says you have a right, but the office can stall you for a year, 2 years, or longer, then your right exists only on paper. And a paper right will not protect you on a dark street, in a bad neighborhood, or during a real emergency. Here's a hypothetical example to explain this. Say you live in a high-crime area. You have been threatened. You decide to apply for a carry permit because you want to protect yourself. You turn in everything. Then the office tells you nothing for 10 months, maybe 12, maybe 18. During that time, you still cannot legally carry. So for all practical purposes, the office has done what it could not openly do by law. It has kept you disarmed through delay. That is why this story matters so much. It is not really about stacks of paper. It is about whether a government office can use time itself like a weapon. And if you think this problem stays in California, think again. Permit delays have become one of the most talked about ways anti-carry systems can survive after losing bigger legal battles. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can protect you. Subscribe so you don't miss it, because this channel is built to help regular gun owners understand the law before the law understands them. Second, let's talk about why delay cases are getting stronger after Bruen. Most people know the name Bruen, but a lot of people only know the headline version. They think Bruen means every gun permit law is gone. That is not true. Bruen struck down New York's old proper cause system. In simple terms, that was a system where officials had too much room to decide who had a special enough reason to carry. The Supreme Court said that kind of may-issue system was a problem. A may-issue system means the government can still say no even if you check the boxes, because someone decides you are not special enough. A shall-issue system is supposed to be different. In that kind of system, if you meet clear, objective rules, the permit should issue. But here's the part nobody's talking about enough. Bruen also warned that even so-called shall-issue systems can become unconstitutional if they are abused through things like excessive wait times or huge fees. That line matters. A lot. Because once you understand that point, you see the real fight. The question is no longer only, can the state demand a permit? The new question is, can the state turn that permit system into a slow-motion ban? Now let's move to Massachusetts, because this is where the story gets even bigger. Massachusetts has been at the center of a separate fight over non-resident carry licensing. In one case, the state's high court said the old non-resident system was unconstitutional after Bruen because it was discretionary. But in another case, called Marquis, that same court upheld the newer version of the state's non-resident licensing setup. And that is where the states came in. A coalition led by New Hampshire, with 25 states total, asked the Supreme Court to step in. Their argument was blunt. They said Massachusetts was burdening non-residents with delays that could run 40 to 170 days, a $100 fee, and a vague suitability standard that still gave officials too much room to block people. Think about the real-world problem there. A law-abiding gun owner can be legal at home, cross a state line, and face a felony risk. That is not just a theory. The Marquis case involved a resident who disclosed he had an unloaded firearm after an accident. He then faced prosecution because he did not have a Massachusetts license. Have you ever wondered why this scares so many travelers? Because it shows how easy it is to become a criminal by geography. You can be following the rules where you started, drive a few miles, and now the rules flip on you. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. But wait, there's something even more important. Even though the Supreme Court later declined that petition, the issue did not disappear. Why? Because the bigger legal idea is still alive. Delays, vague standards, and permit office games are the next major front. Most people think the danger comes only from a clear ban, but the truth is often quieter. The danger can come from an office that says, sure, you can apply. Then it buries you in waiting and extra hoops. That kind of system looks lawful from far away. Up close, it can work like a denial machine. And that is why the DOJ support in California and the multi-state push in Massachusetts matter together. They are different fights, but they point in the same direction. Courts are being forced to answer a simple question. If a right takes forever to exercise, is it still a real right? Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the community of gun owners. Click subscribe now because staying informed is one of the cheapest forms of self-defense you've got. Third, let me tell you what most people get wrong about permit delay stories. They hear about a court win or a DOJ lawsuit and assume the problem is fixed. No, do not make that mistake. A lawsuit is pressure, a court ruling is leverage, a settlement is progress, but none of that means your local office will suddenly become fast, fair, and friendly tomorrow morning. So what should you do with this information? First, know your state's actual timeline rules, not the rumor. In some places, the clock starts only after the application is considered complete, and that word can become a battleground. If an office delays your interview or claims a document is missing, they may argue the clock never really started. Second, document everything. Save emails, save receipts, save appointment dates. Write down who told you what and when. If you ever need to challenge a delay, memory is weak. Paper is strong. Third, do not assume silence means approval. In many states, if your permit has not been approved, you are still not cleared to carry. Fourth, never assume your home state's rules travel with you. That Massachusetts example should burn this into your brain. State lines matter, reciprocity matters, non-resident permits matter, transport rules matter. One wrong assumption on a road trip can turn into arrest, charges, legal bills, and a lifetime headache. Imagine you live in a constitutional carry state. You get used to carrying every day. Then you drive into a neighboring state. You think, I'm legal everywhere because I'm legal at home. That is exactly how good people get blindsided. Some states honor your permit, some do not. Some allow transport only in very specific ways. Now, this is where it gets personal. If you are waiting on a permit right now, you may feel powerless. But these cases show something important. Delay itself is becoming part of the legal fight. The office does not get a free pass forever just because it calls the problem administrative. That view is changing. Like when one office gets challenged, other offices start paying attention. They do not want the same headline or lawsuit. The system may still require permits, but if officials use endless delay to stop you, that tactic is getting harder to defend. Subscribe now because the next video breaks down what steps to take if your application is in limbo. So what's the takeaway? Simple. A permit office cannot hide behind a mountain of paperwork forever. Courts recognize that when the wait becomes unreasonable, the delay itself may be the rights violation. Government red tape is not supposed to cancel constitutional rights. Subscribe right now for you and your family. Stay informed and give yourself a fighting chance. One final disclaimer. I'm not your lawyer, and this is not legal advice. Always check your state law, verify reciprocity, and talk to a qualified attorney if your situation is on the line. See 2026 Script Scene Splitter AI GitHub.